This is that case D, 436896, the Gellner case.
I apologize, Your Honor.
Appearance for the record.
Okay. Eric Roy, 11869, on behalf of Sandra Gellner, is here and present.
Robert Luke, 1489, on behalf of Mr. Gellner, who's also present.
Have you guys talked at all? Come to any sort of...
We probably should have.
let's listen.
I just got here 5 minutes ago,
I
so.
apologize for that.
But there have been no communications at all.
And there may not be much to talk about. You kind of been out of the case for a while. A lot of stuff has happened since then.
I see that.
Let's start with, because I believe by memory it came up once or...
I apologize, Your Honor.
usually it's me, so
It was
it's all right.
silent.
It happens once in a while.
Yeah, let me see it.
Oh, it's
Your Honor, if you just...
of course.
If we could-
I'm so
Now, your bailiff has a weapon that could
He does.
disable
He
that
usually-
cell phone.
Let's shoot this thing.
Please?
Either it won't ring anymore, or you will contact the International Space Station, one or the other.
Oh my God.
All right.
You know, as a judge in Michigan,
Well,
fined himself
oh my
$25 because it was
Hey,
his cell phone that went off during court.
I had to change my ringtones because they, yeah. Marshal Bill, no one's going to attack us. Go ahead and take it out in the hall, and there you go.
There we go. Then we have a
Thank you, sir.
technologically advanced
Please.
marshal with us. All right.
Accept my apologies.
Let's start with one of the easier aspects of it. And again, I know this was sort of addressed when you were in the case,
Yeah.
and I believe it was addressed when Ms. McFarland was in the case. I don't know why we're still bringing up the car issue and the miscellaneous property items. I thought we were done by agreement back then. You, as far as the car, if you want to look at the minutes from September 12th, 2012, when you represented her, the car issues were no longer an issue anymore. So I'm shocked to even see it back. And then I thought the household items we already addressed. You can go pick them up if they're there. If they're not, they're not. But contempt, not going to happen. Not going to happen. The car is not going to happen. It was way back in 2012. On the record. So
He's asked for it last time.
that issue is...
I guess my understanding is the last hearing, Your Honor, in June or July, you admonished the defendant to abide by all court orders when that was brought up.
That's different than you putting on the record the car. I'm not dealing with the cars anymore. We are so done with cars.
We're done with cars. We're
That
done
was
with
done in
cars.
September. The miscellaneous items, I thought he indicated he didn't. Again, I'm going off memory. I didn't go back and review every video, but I'm fairly familiar with this case. I thought that was sort of a non-issue anyway. It's CD players and things like that. If they're in the decree, dial 311. If he's got them, you can go get them.
I
And-
think
Don't think that's really the issue.
I think that's what happened. And if we can just get a statement in court as to whether he has it or not, and we just need him to turn over that property.
I thought we already did this, but you have those items, sir?
Yes, sir. The item that she wanted to pick up was a grandfather clock. I sent her an email and said she could come by any time.
Okay. There you go.
With the police escort. And he would not allow me to get my items.
That one day I
311.
had tonsillitis,
You guys don't get along.
but I sent you an email and
Hold
said
on.
stop by any time.
Dial 311, go over, and get your grandfather clock.
And other
Civil
miscellaneous
escort.
items.
It's a civil escort. And the other items.
As long, yeah, we'll do. I don't think 311's not going to enforce anything. The court
They're
knows
her
that.
items, and if he's got them, she's got an order in her hands with
Okay.
a police civil escort, and she can get them.
They'll enforce. We'll do
And-
that.
And Officer Brown, he was very helpful. He knocked on the door for several minutes, and he said he could not, prior to him knocking on the door, he could not force him to give the belongings. He had the decree, he knew what was going on, and Mr. Gellner would not answer the door.
I had tonsillitis that day. I'll be more than happy to answer the door and give you your stuff.
Okay, so it's on the record. We'll make it happen.
Right.
All right, great.
Right. Listen, doesn't work out, give me a pickup, give me something.
Okay.
We'll sign whatever.
All right.
And that was the only time she came over in about the past 2
listen.
years. Okay?
We're done with the property.
Right.
items.
Right.
Let's be. Listen, I won't reiterate because I've also stated my opinions of the case many times before on the record, so I don't need to reiterate my feelings about the case. That being said, the sum and substance of what's currently requested It's nothing more than relocation. Absolutely is nothing more than a relocation case.
Where do you draw the line, Your Honor? It's in state. What if she's
What ties at all does she have to Lake Tahoe? Listen, she's admitted that reason she's moving there. Her fiance's 3 hours from there.
what's wrong with that?
No, Mr. Boyd, let me ask you a question. Let me ask you a question. Because when it comes to his visitation, and I'm likely going to deny his request to modify custody as well when I consider the Rooney stuff, unless she's inhibiting his contact, and I realize she's, I think, using their terminology, seems unstable because she keeps coming to court asking for these things, but at the end of the day, he's still getting his contact. The issue's not her. She's not in the relocation part of the state. We don't take her into consideration.
I get
You
that.
tell me
I
how
get
these
that.
two kids are benefited by this.
I'm
Without mentioning your client whatsoever.
Right.
Tell me how it benefits them to move up to Lake Tahoe, to a place they've never lived before, to go to school where they've never gone before, to modify their contact with their father that they've seen every weekend. And again, it's not a relocation case by your admission. You tell me how doing that benefits these kids.
financial stability. She'll have a job up there where she can
I don't
earn.
know that. None of that was submitted to me.
It's in the pleadings that's what she'll do.
Working for him in California?
How it works is they distribute kits for cars, and she's going to be involved in the distribution out of Tahoe, so she'll have employment there.
Why can't she do the same thing in Nevada or Clark County?
It's further away geographically. It's several hours from Tahoe to where he is in California.
Right. Again,
whereas
let's take. How are these kids? They already received child support financially. She's going to be financially better off. Okay.
Right. But
How are these kids going to be better off?
I get your point. Believe me, I understand the perspective, and it is about the kids. I get that, but at the same time, we can't chain her. How are we going to chain
You're
her
arguing.
to Las
You're arguing a
Vegas?
relocation case.
But this is not a relocation case.
Mr. Roy, you're talking circles. It's not a relocation case, but I'm going to cite the chaining her to the state of Nevada stuff. Has nothing to do with her. Take it. How are these kids? She's out of it. How are these kids benefiting by moving up to Tahoe for his visitation purposes?
We can compensate and give him exactly as much visitation as he has now. That's not a problem.
I don't think they want to negotiate. That's my question. How are these kids going to be benefited by moving, I can't remember, 8, 9, 10 hours away to a community they've never lived before, no friends, new schools. I don't even know what the school system Washoe compared to Clark. I have no idea.
Okay, well, Your Honor, if I don't know what you want to do with this case. I get a feeling what you want to do.
I'm going to deny it unless you can give me even
I
two or
would
three reasons.
assume, and I'll be happy to submit evidence. You want to set up for an evidentiary hearing, whatever it is, that demonstrates that Washoe County schools perform better than local schools here.
I still wouldn't grant that.
But my question is, why are we? Because you're essentially doing a Schwartz factor analysis. How does it affect?
I am
the
not
children?
doing. You're missing. I'm not doing. You're trying to incorporate Schwartz. We are done with the relocation. You are trying to turn this into an interstate relocation to benefit her, and I get what you're trying to do. But the issue is visitation. The issue is how your request to move them up to Tahoe is beneficial to these kids.
But why do we have to do that analysis if he's going to receive the exact same visitation? His visitation is alternating weekends right now. We don't even have to alter that. His visitation doesn't change.
You're now putting it on him. I'm asking you, how does it benefit these kids? Because that's the issue. How does this benefit these kids?
They live with their mother. Their mother is now going to be a happier person. They're going to be in their mother will now be allowed to marry her fiance, be in a relationship up there.
We're back to mother. I'm asking you, these kids, how are they? Take her out. Take him out. How are these kids going to be benefited by moving to Tahoe? That's what the issue is. That is absolutely what the issue is.
And Your Honor, I can't say we have family support there. I can't say for sure if the school system is better than there. But nonetheless, I don't understand, where are we going to draw the line? Can she not move to Henderson?
I didn't
Can
say
she
that.
not move to Ely?
I don't think
it's
they said
an
that.
in-state move. I just don't see why we're doing a best interest analysis in the first place.
First of all, by their agreement, if they ever change schools, they have to do so by agreement or they come back to court. So I wouldn't be moving from the schools.
And that's why we're here before you, because of that single provision.
And I'm not modifying that, Mr. Roy. I'm not.
But that changed, so that means she can't move. Even the result of that would mean that she can't, even within the Las Vegas or Clark County district.
Didn't say that.
Can't. But that's
Do you have
that
any problem if she
provision.
moves within Clark County, Mr. Luke, as long as these kids stay in the same school?
As long as they stayed in the same school, I mean, I don't think you'd have a problem with
The
that.
kids have to be zoned in her school. That's what I'm saying. She's the primary custodian. They're going to follow her zoning.
Right,
That's what I'm saying. Is it?
I'm denying your motion. This is nothing more than it's nothing more than a motion to relocate. Again, within the state of Nevada, I've heard nothing yet, no evidence whatsoever, that these kids, it'd be in their best interest to move them up to Tahoe. None. And even if your client's going to yet recoup and try to come to court that show me Washoe's a little better than Clark, that's not going to make the day either. In this court's mind, school, half of it's educational, half of it's socialization. Why would I rip these kids away from the friends and everybody that they've known for all these years because she wants to go to Tahoe? Not going to happen.
What if we conducted a child interview and the kids want to go? Would that change the court's opinion?
No. No. So the request to move them from their current schools is going to be denied. Again, I'm very familiar with the history. It's nothing more than an interstate relocation, which, to be candid with you, it'd be easier if she went across the border to Utah or Arizona. At least they'd be closer. Just because you go up to the tip of Nevada and interstate, it's not going to change anything. As far as child support, the motion was worded in that it's been 3 years since the decree was filed. We don't go by that. We go by the last time child support was reviewed. I show child support was reviewed in November of 2012, so we're not on the 3 years. If you're asking for documentation or discovery regarding his as to whether he qualifies for the 20% change, I'll give you 30 days to request financial discovery. I would hope that they would just voluntarily give it to you.
In November, one of the
Did he file a financial disclosure form, Mr. Luke? I didn't get an updated one.
No, they hadn't changed.
I still need him to update it, though, so.
Well, it would have been a repeat. All we'd have done is attach the same one with a cover page on it because
That's fine.
he's under, because they froze, the government, federal government froze wages. His income hasn't changed. He's still in the same house, same basic expenses. So there really was nothing to update. That's why we talked about it, but we just said, well, there's nothing left for us to add.
As far as, again, I've alluded to it, but I get that your client's frustrated with the plaintiff's multiple attempts to try to circumvent the law at this point. I don't find that, and I realize you cited I believe it was it's an out-of-state case, but I'll submit to you, Prim versus Lopez is a local case. It actually talks about a parent's stability, their employment, their long-term whatever. So, but I don't have that yet. I have a mother that's very adamant she wants to move up with her significant other, and because I'm not granting that, I can't really find a ground to modify custody.
No, that was all the domino thing.
If she goes, he obviously they're not leaving.
Right. If she's not leaving, then this our motion is moot. But we have to file to protect ourselves in this matter, as we've done before.
Your Honor, if I could just have 1 second to speak to opposing counsel. Sure. With indulgence.
Well, but here's the thing. The decree never defined what starts the weekend. Scientifically, the weekend starts on Friday, so for the Friday is the first of the month. That would be the first weekend. The weekend started on a Saturday. And there was nothing in the decree that defined what the Saturdays are.
Okay.
I mean, what starts a weekend. Okay, yeah, and then the problem was, if she's literally seems to take the kids out of school, but take them to races and things like that, that's what he's adamantly opposed to. No. Just
Listen, why don't we do this? I don't mind anybody feel pressured. We've got a couple more we can call. If you guys come to an agreement, come back, we'll put something on. If you don't, listen, I'm just simply denying motions on both sides, so.
No, we'll go out in the conference room and see if we can discuss it. You can move on to other matters.
If you don't reach any agreements, the motions are just going to be denied, so.
Either one.
She can't let you know.
Yeah, that should be fine.
Okay. Actually, the following one.
The following?
Yeah.
Okay. We'll take this, get him the next weekend.
Yes, definitely.
All right, we just-
Are we discussing?
That's contingent on the kids not missing school.
Yeah, right.
He's got to submit an FDF.
That's contingent on the kids not missing school.
Yeah, the kids aren't going to miss school, are they? Are the kids going to miss school?
Either Friday or Monday.
I,
Just tell me, what time are they leaving at?
Thursday after school. Thursday after school because.
You got extended family in
I
town?
have extended family coming in.
Friday?
They-
They've been missing so many days. I've gotten letters that I
Where,
followed.
where
with
we
the
go in
court.
the hallway?
Yeah, that's my preference.
Okay.
Again,
Apologize.
Some other
you
things.
come to some agreement, come back in and put it on, otherwise.
Thank you.
We'll be done.